Thank you, Mr. Chairman. Thanks to all the witnesses for being here. Can any of you compare the amount of data, the amount, volume, type of data that the government has been able to collect using these tools with the amount, volume of data that private companies, and I'm thinking specifically of Facebook, Google, maybe TikTok, what are we looking at? Are they comparable? Has the government collected it, or is it able to collect much more? Do any of you have a sense of that? I'd just be curious to know.
It really depends on the type of information that you're talking about. But if you're talking about electronic information, we can only get the information with legal process that's targeted in a particular case. It depends on the companies, but a lot of the companies maintain, it's the data of their customers, but they maintain full access if that's the answer to your question for their own commercial purposes and so forth. So they would have access to vastly larger quantities of data than the government could get pursuant to legal process.
And not least because you do have to go through some sort of process. I mean, it varies, I understand, depending on what exactly it is you're collecting, but Google and Facebook and TikTok and whomever else, they don't have to go through, once they get their users' consent nominally, which they usually don't really even ask for, then they have access to geolocation data, search data, phone books, messages, et cetera, et cetera. Am I right about that?
Absolutely, that's totally correct.
Yeah. Switching gears just slightly, let me ask you about the business records provision in Section 215. How has the FBI used this authority over the last couple of years? Can you give me a sense? And what would it mean for the Bureau's ability to counter terrorism, other threats, if your ability to obtain business records information went away? Just give me some perspective on that.
We use it in a variety of ways, mostly as a building block. For instance, as I stated earlier today, in a terrorism case, oftentimes when a homegrown violent extremist begins to mobilize for violence, he attempts to procure weapons, whether a knife, or rent a vehicle, or a bomb-making material. The business record enables us to get those sales records to determine that he is doing that so we can disrupt him. Additionally, we oftentimes use the business records for electronic communication transactional records. That is, who are you communicating with, but not the content. That has been especially helpful in our counterintelligence investigations as we try to build out the networks that the intelligence officers are building to recruit U.S. persons. We also use that in the same way our terrorism cases as well. As far as what would happen if we lost this provision, what we would be able to acquire would be limited down to 4 areas. We wouldn't be able to get the totality or the equivalent of what a grand jury subpoena could get. In addition, in our counterintelligence cases, the only way we're able to get that electronic communication transactional records is through business records. Most companies don't comply with the national security letters. In counterintelligence investigations, oftentimes a crime has not been committed, so we wouldn't be able to declassify that information and then go to a grand jury for that. And then lastly, the standard for the business record would increase from relevance to the investigation to something higher to specific and articulable facts that this pertains to an agent of foreign power.
Thank you very much. That's very helpful. Let me ask you this. The biggest change, as I understand it, that came with the USA Freedom Act was the end of bulk collection of data. And I'm wondering what difference this has made operationally over the last 4 years and what, if any, changes need to be made to the current system of requesting detailed call records. Go ahead, Ms. Morgan.
So, sir, thank you for your question. So just if I could level set a little bit
please.
between the 2 programs. So under the bulk program, the providers, the telecommunications providers, would give NSA metadata. Again, we were limited to metadata, and they'd give it to us in what else characterizes an indiscriminate fashion. Whatever they technically could give to us is what they would give to us. Internally to NSA, there would be an approval process that the appropriately trained analysts would have to go through to be able to have, say, a phone number and look into that data. So that was the bulk program. Under the program that we just decommissioned that we're here talking about today, the process is a bit different. The providers hold on to the records in bulk. Our process is much more targeted. So what happens is an analyst might say, I have this phone number, and I have a reasonable articulable suspicion that the user of that phone number is involved in international terrorist activities. We would coordinate that with the FBI and with DOJ, and we would file through DOJ an application with the FISA court. If the FISA court agreed that we met the appropriate standard, then they'd be able to compel the telecommunication providers to give us records, metadata records only, associated with that particular phone number. Now, when you look at the 2 programs, there's, some differences in that One being that now we have a court approval process in place now. So you could say, you know, anything that has a court approval process in place is not as quick as something that doesn't have an approval process in place. So that's, you know, one particular distinction. In terms of our data integrity and our compliance concerns, since those issues were related to the underlying data that we were getting from the providers, we assessed that we would likely have those similar kinds of problems in a bulk program as well, because it's just the mechanism by which you're getting that data.
That's helpful. Thank you very much. Thank you, Mr. Chairman.